Thank you for your time and welcome to the information session. Today we will be presenting an introduction to continuing care inspections, what Albertans can expect, Alberta Health's inspection and compliance monitoring program.
This is the overview of the presentation for today. We will be covering an overview of terminology in the Continuing Care Act, introduction to the Licensing and Compliance Monitoring Branch, inspections and complaints. In the complaints section, we will be providing general information about how our licensing office handles complaints under the new Continuing Care Act. However, if you do have specific concerns or complaints with regards to care or accommodation services, you can send those via the email cclo@gov.ab.ca. The contact info will be provided again at the end of the presentation.
The purpose of today's presentation is to highlight how Alberta Health monitors compliance to legislation and standards. Operators and providers are required to ensure the health, well-being, and safety of residents and clients. If you do want to know more about the legislation as a whole, we encourage you to visit the Continuing Care website and access the recording for the Part 2 information session. We will discuss what the operators and providers are required to do and how inspections are completed and reported. It's important to note there was previous legislation that did address monitoring and compliance in continuing care, but it was complex, fragmented, and outdated. A significant reason for the new continuing care legislation is to address gaps with the previous legislation. Inconsistencies and gaps for compliance and monitoring existed around licensing, authority to inspect and respond to complaints, and the ability to exempt operators from specific licensing requirements. There is now legislative oversight, meaning Alberta Health has more consistent authority over continuing care settings. Alberta Health can now monitor compliance and apply enforcement as needed consistently across all continuing care settings. Operators and providers remain committed to meeting the requirements. Also to acknowledge is to understand that there has been a lot of challenges in the sector, especially over the last few years with the COVID-19 pandemic. We hope that these challenges will start to be addressed through this new legislation and other initiatives to improve the continuing care system. If you have questions, you can send those questions to the Continuing Care Licensing Office at cclo@gov.ab.ca. Additionally, we encourage you to browse the Continuing Care in Alberta website for various resources that you can access to learn more. The Continuing Care Act. The Continuing Care Act and regulations introduce new terms for the different continuing care settings and services. The most significant change is the new terms of continuing care homes, which brings under one term the settings formerly known as designated supportive living and long-term care, and introduces publicly funded hospice spaces and settings. We refer to home care as home and community care. Licensed supportive living, the non-designated supportive living, is still referred to as supportive living accommodations. We will go into a bit more detail for each setting in the next slide. Sites include group homes, lodges, supportive living accommodations, designated supportive living, long-term care, and home and community care offices. Further in the presentation, we will go into what the standards are about and how they are monitored in continuing care for compliance. For now, these are the licensing expectations for each setting and the standards that apply. Operators and providers must meet core requirements and meet minimum standards. Under the Continuing Care Act, a continuing care home admission is based on assessed needs for the health services funded at the site. All continuing care homes must be licensed, and there are 3 types of continuing care home, which differ based on the levels of care provided at each. In a continuing care home, all types are licensed. The accommodation standards and continuing care health service standards are applicable to types of continuing care home, with the exception of Type C hospice, in which currently accommodations and continuing care health service standards do not apply to hospice settings. Further communication will be shared with hospice operators on this process. Standards will be further reviewed post-implementation of the Act, considering what would be most applicable to hospice settings. More to come and will be communicated to stakeholders. Type A, this is what was previously known as long-term care, which included nursing homes and auxiliary hospitals. most auxiliary hospitals function like long-term care and will be considered continuing care homes. Residents of Type A continuing care homes are individuals with complex medical needs who can't safely reside at home or other types of continuing care accommodation. Type B, this is what was previously known as designated supportive living, which includes designated supportive living 3, 4, and 4D. Residents in this setting are individuals with complex medical needs who can't safely stay at home or in supportive living, but do not require the type of support provided by Type A continuing care homes. Type C, we are also bringing publicly funded hospice settings into the new legislative framework. Type C continuing care homes house individuals approaching the end of life with a life-limiting condition. Admission typically occurs in the last 3 months of life based on assessed unmet needs. Supportive living. Supportive living accommodations are licensed. The definition for a supportive living accommodation includes settings where services are arranged for or provided by the operator, meaning they are not publicly funded for facility-based care, and the operator determines admission criteria. A supportive living accommodation that does not have an agreement with the Regional Health Authority. In this case, Alberta Health Services is the Regional Health Authority and delivers many of the care-related services in the province. To provide facility-based care, meaning they are not a long-term care or a designated supportive living, now known as a continuing care home, type A or B. The minimum requirement is that they provide one or more of services to support the safety, security, or personal welfare of residents, and they provide one or more of services such as meals, housekeeping, or other hospitality-like services. The accommodation standards are applicable to this setting. Under the new legislation, there are 3 types of home and community care. Type 1, when the Regional Health Authority is the provider. In this category of home and community care, services are delivered directly by AHS employees, the Regional Health Authority. Type 2, when a home and community care provider is contracted by Alberta Health Services, the Regional Health Authority. In this case, home and community care services are delivered by a separate organization from AHS, but under contract to AHS. Type 3, when home and community care providers are directly hired or arranged by clients themselves. Examples include self-managed care and client-directed home care invoicing. Home and community care is not licensed, and the continuing care health service standards are applicable to Type 1 and 2 home and community care settings and not to Type 3 settings. Introduction to the Licensing and Compliance Monitoring Branch. There are 6 guiding principles that guide the work of the Licensing and Compliance Monitoring Branch: accountability, fairness, consistency and impartiality, transparency, risk management, and a focus on excellence. Alongside the principles is the use of administrative fairness, which affirms fair decision-making and administrative processes. With the guiding principles and administrative fairness steering the work, the branch works with operators, providers, residents, clients, and their families to improve accommodation services and the provision of publicly funded care to Albertans. In the Licensing and Compliance Monitoring Branch, there are a variety of staff dedicated to providing oversight and assurance services to Albertans. The branch primarily focuses on ensuring quality of care and accommodation services for Albertans in continuing care, which includes the licensing office, inspections, health compliance, and business supports, which includes public reporting of inspection results. The licensing office issues licenses, responds to licensing questions, and provides consults to applicants and operators, and triages incidents and complaints from the public. Inspections and health compliance conduct inspections and ensure operators and providers provide safe care, monitor to assure Albertans of care and accommodation services, investigate alleged complaints, and follow up to incidents. Inspectors also come with an extensive breadth of experience in seniors housing and healthcare, which includes nurses, public health specialists, safety codes officers, and licensing specialists. Operational policy and compliance reporting develop operational policy, develop risk-based compliance monitoring tools and processes, post inspection results on the website, and establish compliance reporting for the public. The branch collaborates with collateral authorities, which includes, but not limited to, fire, protection for persons in care, the Alberta Health Advocate, etc. The inspections process. We're going to talk about the inspection process in a bit more detail now. Alberta Health employs a variety of approaches to monitor compliance. This might involve having a conversation with the operator or site administration about the accommodation standards and continuing care health service standards, and various ways in which compliance can be achieved in their particular setting, offering consultation to prospective applicants in initial site visits, attending a resident and family council to see how administration is listening to suggestions for improvement and concerns, or issuing immediate actions during inspections when deficiencies are observed. The inspection process largely remains the same under the Continuing Care Act as it was in previous legislation for operators and providers, but there will be a small number of important changes, particularly in roles and responsibilities. Beyond that, all operators and providers will continue to be inspected on a regular basis against the Act, regulations, and standards, and investigations will take place as needed to follow up on specific identified issues, complaints, or concerns. During an inspection, the inspector tours the facility, and in the case of home and community care, the Home and Community Care Office. It makes notes of their observations. As part of the inspection process, the inspector may also ask questions, take pictures, review a sampling of records, policies and procedures, access electronic data processing equipment, and speak with the person in charge. The inspector may also interview residents, clients, family members, and staff. The inspector then determines whether the operator complies with the Act, regulations, and standards. At the end of the inspection, the inspector's findings and conclusions are reviewed with the operator or provider and any other person the inspector or operator or provider considers appropriate. The inspector provides a copy of the inspection report to the operator or provider. It includes the non-compliances issued, any orders that may have been issued, and the timeline for the operator or provider to come into compliance. If the operator does not meet all of the requirements, the inspector may take additional compliance and enforcement actions. All these steps and decisions will be communicated to the operator or provider. If requested by the operator or provider, an inspector may make an educational visit to a site or office to provide information on licensing requirements as applicable and the inspection process. An inspector may also visit a site or office in between scheduled visits to follow up on non-compliances, provide information, for example, on the Act, regulations, and standards, follow up on an incident, or review compliance with specific requirements of the Act. At this time, home and community care and Type C continuing care home inspections are not publicly reported, but will be reported in the future. The following is the approach to inspections under the Continuing Care Act. Differential monitoring, sites seen more frequently or less frequently depending on risk and compliance history. All sites inspected within an 18-month timeframe post-implementation of the Continuing Care Act. Inspections and monitoring visits may occur at any time throughout the year. Inspectors may periodically attend resident and family council meetings. Note, the majority of inspections will continue to be unannounced. Complaint investigations conducted separately from inspections. Streamlined inspections include the Continuing Care Health Service Standards and the accommodation standards at the same time where applicable. There are also other areas of the Act that apply, such as reporting requirements, which we will go over in the presentation, and complaints. For example, Alberta Health may follow up at a continuing care site to follow up to a complaint. The purpose of the accommodation standards is to ensure that all operators maintain a high quality of accommodation services that promote safety, security, and quality of life for Albertans living in continuing care homes and supportive living accommodations. In an inspection related to the accommodation standards, the following is considered imperative: maintenance, regular, daily, monthly, quarterly, annually, biannually, etc. We look at the safety of the building, internally and externally, surrounding grounds. We look at the cleanliness of the building. We look at the food, nutrition, hydration, serving, variety, seasonal, feedback, etc. We look for a registered dietitian approval of the menu. We look for varying menu, regular, mince, puree, etc. We speak with the resident regarding their living experience, how they like living in the facility. what options residents have for laundering facilities and costs incurred, risk management agreements, the frequency of review, outcome, reassessments, etc., ensure all staff have appropriate training in criminal record checks, and who oversees resident finances and replacements of belongings. These could both be non-applicable if the facility does not offer these services. We encourage you to look into the standards on the Continuing Care website in further detail. The Continuing Care Health Service Standards set the minimum requirement that operators in the continuing care system must comply with in the provision of publicly funded healthcare. In an inspection related to the Continuing Care Health Service Standards, some areas we look into are infection prevention and control, care planning and assessments, medication management, case management, at how oral care is provided and how often residents are bathed, including the safe water temperatures, how restraints are being used at accommodations, staff training, how information is shared when residents are needing to access the hospital, for example, or are moving into another site or level of care, nutrition and hydration. The image on your screen demonstrates Alberta Health's gradual approach to compliance monitoring and enforcement, with the guiding principles and administrative fairness forming a base for the approaches that are used to encourage and enforce compliance. Alberta Health works to inform, encourage, and engage. Alberta Health focuses on preventing non-compliances, which means an operator or provider is not meeting a requirement of legislation, by working with operators and providers and offering education regarding the requirements of the Act, regulations, and standards. For example, on alberta.ca, there is a variety of educational and guidance documents available to support operators, providers, residents, clients, and their families. You're encouraged to have a look at what is available to help you further understand what is required. Still in the blue part of the pyramid, the bulk of our activity includes inspections, which are mainly unannounced. Situations where an inspection may be announced typically are seen when a new operator is opening a site to check in that requirements are being met prior to opening. Moving up the pyramid, we see some of the enforcement measures that may be used. When a non-compliance is identified, Alberta Health will use a gradual approach to enforcement. This starts with a risk-based assessment to determine the appropriate enforcement measures to be used, and a review of the operator or provider's compliance history. Risk is indicated on the slide by the low to high arrows on the sides of the pyramid. If there have been serious high risk or repeat non-compliances, and those issues are negatively affecting the health, safety, or well-being of residents or clients, Alberta Health will use the most appropriate enforcement tool for the situation to bring the operator or provider into compliance. A compliance and enforcement response is equal to the identified risk and provides the operator or provider with an opportunity to come into compliance. When the risk changes, or considerations related to risk change, Alberta Health may change the type of enforcement response and the type of corrective actions to suit the situation. The pyramid shows this process. You will notice that the enforcement pyramid starts with license conditions and a specified measures order and escalates to a court order. Enforcement and compliance is a process which rarely escalates beyond the foundational steps. But on seldom occasions when required, there must be steps to ensure the health, safety, and well-being of residents or clients. And this is done through escalated enforcement, including stop orders, license cancellations, or fines. Compliance timelines. Expectation. Operators and providers must come into compliance as soon as possible to ensure a resident or client's health, well-being, and safety. Follow-up. Alberta Health will follow up with the operator or provider after an inspection has occurred. If the operator or provider is not making reasonable progress, Alberta Health may also consider additional enforcement measures. Alberta Health works with operators and providers to understand the requirements of the Act, regulations, and standards, and uses administrative fairness when making enforcement decisions. After the inspection, Alberta Health will support the operator and provider in a process towards achieving compliance by communicating the expectations and regularly following up with progress. During this time, operators and providers are encouraged to submit evidence sooner than the required timelines, as non-compliances can be rectified sooner than the timeline. It is important to note, as discussed in the previous slide, there is a progressive approach with respect to the appropriate use of enforcement action in response to the type or severity of noncompliance. If there have been serious high-risk issues or repeat instances of noncompliance in a specific area of operation, and those issues of noncompliance negatively affect the health, well-being, and safety of residents or clients, Alberta Health will action escalated enforcement strategies to bring the operator or provider into compliance with the legislation. Alberta Health chooses the most appropriate actions for the situation based on several factors, such as a risk-based assessment to the health, well-being, and safety of residents and clients, and the compliance history of the operator or provider. There are 3 levels of risk based on the severity and seriousness of the noncompliance and its impact to residents or clients. Enforcement actions issued are equal to the risk identified, and enforcement measures are progressive in nature. This provides that operator or provider the opportunity to achieve compliance within a designated timeframe. There are rare instances where the situation may be serious enough to warrant intermediate action by the operator or provider, or even immediate enforcement by Alberta Health. Overall, many of the enforcement measures under the Continuing Care Act are consistent with previous legislation. Administrative monetary penalties is new. This enforcement measure has been introduced in order to offer an intermediate enforcement measure between specified measures orders and canceling a license. Please note that implementation of administrative penalties has been delayed until 2025 to allow for further stakeholder engagement on the process. Now that we have reviewed the type of accommodations and settings, we encourage you to review the public reporting on the Standards and Licensing website. You are able to enter the name of the facility and review the type of license issued and inspection results. At this time, home and community care and Type C continuing care home inspections are not publicly reported. Should this process change, operators and providers and the public will be informed in advance. There are also reporting requirements for operators and providers, specifically notice to director and duty to notify. Operators and providers have reporting responsibilities in these 2 key areas. Notice to director, notifying the Continuing Care Licensing Office in advance of any changes to a continuing care home or supportive living accommodation services or operations. Please note the director in these circumstances refers to the individual appointed by the minister for the purposes of the Continuing Care Act. Examples to changes to operation, ownership, and provision of services include business name change, operator contact change, continuing care home, supportive living accommodations contact or name change in funding, declaration of bankruptcy, filing of receivership, changes in services offered or contracted services, and other changes. Examples of changes to licensing requirement status include noncompliance to the Public Health Act and Safety Codes Act, unsatisfactory result of a fire inspection, unsatisfactory result of a safety inspection, licensee no longer holds municipal permits or zoning approvals, licensee no longer maintains an insurance policy, change in maximum occupancy, change in building layout, and duty to notify. Continuing care home and supportive living accommodation operators and home and community care providers must report to Alberta Health an event of an injury, potential injury to residents and clients or other duty to notify incident. Examples include unexpected death, serious harm not including alleged abuse, serious harm including alleged abuse, extensive damage to the accommodation or continuing care home, unplanned activation of a contingency plan, resident client unaccounted for, termination of a home and community care type 2 agreement, a home and community care provider that is contracted with the regional health authority, staff strike action, a breach in confidentiality with significant consequences, an event that would generate media coverage. An offense under any of the following enactments, regardless of whether the conduct was the basis for the conviction, occurred before or after the coming of force of the Continuing Care Regulation, include the Continuing Care Act, the Nursing Homes Act, the Protection for Persons in Care Act, the Public Health Act, the Supportive Living Accommodation Licensing Act, a regulation made under the Continuing Care Act, and the Criminal Code of Canada. Also new to the Act is the ability to grant exemptions to continuing care home operators and home and community care providers. Exemptions are available in limited circumstances for operators who believe that a requirement does not apply to their specific setting, the residents in their care, or who are unable to meet a requirement within the legislation. Exemptions are temporary and time limited. The continuing care regulation includes the ability for Alberta Health to exempt continuing care operators and home and community care providers from specific provisions identified in the continuing care regulation in certain instances. The exemption is intended to provide limited flexibility while still ensuring the safety, security, and well-being of residents and clients.
Complaints and concerns. Complaints and concerns about continuing care accommodations and services can be made to Alberta Health. Complainants are encouraged to work with the facility or home and community care provider as the first step to address their concerns prior to contacting Alberta Health. If concerns remain, the Continuing Care Licensing Office can be contacted to make a complaint at the contact information listed on the slide. In a continuing care home or supportive living accommodation, this information must be provided to the resident upon admission and on request of the resident and/or resident's legal representative, and with each update. Staff will be provided the information at the beginning of their employment and when requested. Home and community care providers must provide this information to each client that is provided home and community care upon first receiving care and on the request of the client or client's representative and with each update. Staff will be provided the information at the beginning of their employment and when requested. Complaints can be submitted by phoning the complaints line by email, fax, or mail. Alberta Health will gather the contact information, nature of the concern, relation of the resident or client if applicable, and name and address of the accommodation or name of the home and community care provider as applicable. When the complaint is received, Alberta Health reviews to determine if it's within jurisdiction to investigate. Alberta Health may refer the complaint to another authority if applicable, such as Protection for Persons in Care, the Police Service, the Alberta Health Advocate, etc., depending on the details of the complaint. Alberta Health will notify the complainant of the outcome of any investigation or reason if the complaint was not investigated. Investigations may occur as an inspection. The Act also includes complainant protection. The intent of complainant protection is to deter and reduce the risk of retaliation to a complainant or any person acting on behalf of a resident or client where there has been a complaint to the Act, regulations, standards, codes, or guidelines. Operators and providers must ensure complainant protection for any person who wishes or attempts to make a complaint in good faith. No operator or provider will take, direct, or threaten to take any measure or conduct that adversely affects a person because they made a complaint or a complaint has been made on a person's behalf. The complainant may request to the director that any identifying information not be shared with the operator, provider, or staff members. However, in special circumstances where the health, well-being, or safety of a resident or client is at significant risk, the director may authorize disclosure of relevant information needed to support the resident or client. When a complaint is received, Alberta Health reviews the details of the complaint, along with the risks to the residents or clients, and determines next steps and response timeframes. The director is notified of any complaint suggesting any form of imminent risk to residents, clients, or staff. If there is not enough information provided about the complaint, Alberta Health will attempt to contact the complainant for more information. Should Alberta Health not be able to obtain additional information, follow-up may not be initiated. Information related to the complaint may be shared with a collateral agency such as Protection for Persons in Care, the Alberta Health Advocate, the Police Service, etc., if the complaint relates to their area. If it is decided that an on-site investigation is needed, the inspector will make arrangements for inspection. The investigation may be announced or unannounced at the determination of Alberta Health. It is primarily unannounced. There may be times where a complaint can be investigated through a review of documents sent by the operator or provider to Alberta Health. It would depend on the complaint. The inspector will consider any existing non-compliances of the operator or provider while completing the site visit. Enforcement actions may be issued if appropriate, such as a specified measures order, stop order, or license cancellation if the operator or provider are found to be in non-compliance as a result of the investigation. The results of the investigation will be provided to the complainant, operator, provider in writing and publicly posted. Operators and providers are required to post any issued orders in a prominent place of the accommodation and providers in the home and community care office.
That ends our session. We appreciate your time and attention.
The following documents are available on the Continuing Care in Alberta website. These resources are intended to help residents, clients, and operators and providers in understanding the requirements in the Act, regulations, and standards. There are 3 information guides on the provincial standards, Continuing Care Health Service Standards and Accommodation Standards, and 2 handbooks, Getting Started Continuing Care Licensing Handbook and Guidance for Home and Community Care, providers as resources.
If you have a licensing or compliance monitoring and enforcement specific question or a complaint, please submit it to the Continuing Care Licensing Office at cclo@gov.ab.ca.